Hey guys, today I'll be talking about the key changes to RSMS, ENS, and 482, which happened on March 2018. So, a lot of applicants have been coming up to me and they're really confused regarding what options do they have if they want to if they want to opt for employer sponsorships or working visa if they already have a working if they already have an employee who wants to do working visa for them. So I've made a couple of slides and hopefully it'll address all your working visa and RSMS, ENS, and 482 questions and quandaries basically. And before explaining what sort of rules and regulation changes happened, I'll just give a brief explanation of our company. So I represent Visa Fast Migration Consultancy, and we have a 99% approval rate. We've been operating since 2007 and have launched 10,000 files till now. Everything from student visas, tourist visas, to partner visas, business visas, and even employer sponsorship visas, training visas, etc. We have a combined experience of 20 years. So our staff in India, so we have offices in India and in Australia, have a combined experience of 20 plus years. And coming on to the main topic of the rules and regulation changes from March 2018. The first thing so I've made a couple of slides, and the first thing which I'll talk about is the occupation list. So if there's two ways of sponsoring employees and sponsoring people who are non-permanent residents and are not citizens. So you can either go with the ENS option, direct entry or TRT, or RSMS, direct entry or TRT. ENS is basically subclass 186, and the employer can sponsor the applicant throughout Australia. So this option is available throughout Australia, whereas RSMS option is only available in regional areas. So I'll just provide a link in the description box which tells you which places in Australia are regional. Basically, other than Sydney, Melbourne, Perth, and Brisbane, most of the areas in Australia are regional. So the employer can do RSMS visa for the applicant. If you want to do ENS, then only those occupations are eligible for ENS if your occupation is in the medium and long term strategic skills list, which is the MLTSSL. I'll also provide a link on the which occupations are basically in the MLTSSL. There's a long list to it, like nurses, teachers, etc. For RSMS, if you want to do direct entry, unfortunately TRT is not available. But if you want to do direct entry, then your occupation should be in ROL list, which is regional occupation list. I'll provide a link for the ROL list as well from the Department of Home Affairs. So the ROL list you can use for direct entry. No options for permanent visa through TRT if your occupation is in the STSOL. So basically, what the Immigration Department is saying is that if your occupation is in medium and long term strategic skills list, then you have high chances of applying for permanent visas through employer sponsorship. If not, then if your occupation is in STSOL, then you have very limited options or no options. Your occupation should be in the ROL list for RSMS sponsorship. So RSMS sponsorship, if you look at the ROL list, it has all of the MLTSSL list occupations and some extra occupations as well. So if your occupation is not in those extra occupations, then it will be very difficult for you to apply for permanent visa through employee sponsorship. The TSMIT requirement. TSMIT is basically temporary skilled migration income threshold, and basically guaranteed earnings or guaranteed salary of the applicant from the employer per year. It has to be 53,900 at least. This is a benchmark, and a lot of sponsors need to follow this benchmark, but they don't necessarily have to go for this level. So, for example, this differs from case by case basis. So, if some PR or citizen who's in the same role is getting much more than 53,900, for example, I'm an employer and I have two people working in the same occupation and same role, and they're getting paid 60,000, who are permanent residents or citizen, and I'm sponsoring someone who's not a PR or a citizen with 53,900, then it's very difficult to get an approval because the income of the migrant or the person who you are sponsoring should be at least equal to, if not more than, any permanent resident or citizen in the same occupation and in the same field and doing the same duties. So this might be a bit confusing for you guys, but you can feel free to contact me, and then I can make a personalized TSMIT for your company. So the work experience requirement has changed significantly. If you are doing ENS subclass 186 or subclass 187 direct entry, both of these subclasses, both of these visas require 3 years of relevant work experience in the relevant occupation, and direct entry, which is direct permanent residency visa, also requires 3 years work experience in the relevant occupation. But if you are doing subclass 482, so in the previous videos, if you check that I've mentioned subclass 482 requires, even for applying for this visa, requires 2 years of work experience. So if you have applied for subclass 482 and your occupation is in STSOL, then you don't have any option for permanent visas, because in subclass 482, being a person who has occupation in STSOL, you will only have 2 years of working visa, which you can extend onshore as well, but you would not have any option of permanent visa through employee sponsorship after the expiry of your working visa. But you can surely opt for general skill migration, which is points based. So if you are stuck in this situation, you can feel free to contact me in the details provided to you in the description box. Sorry. So the temporary residence transition requirements have also changed from subclass 457, which was before March 2018. You had to work for the employer for 2 years to apply for a permanent visa. But right now, because of subclass 482, your occupation should be in MLTSSL firstly, and you should be working for that employer for 3 years, after which you can apply for a permanent visa. So it has changed from 2 years to 3 years. Also, the occupation should be only in the MLTSSL and subclass 482. Even before applying for subclass 482, you need to have 2 years of experience. So they've made it quite difficult for employers to employ someone on subclass 482, to be honest. So sorry, the other requirement which has changed, the other factor which has changed, is the age requirement. So before 457 or any application, the age requirement was under the age of 50. Sorry, for 457 there is no age requirement, but if you had to apply for permanent visas such as RSMS and ENS, the age requirement was had to be under 50, but now it has changed to under 45. Exemptions available on this factor, which I'll discuss in the later slides as well. So the training requirement, training benchmark A and B, has been replaced by Skilling Australian Fund. So depending on what company you're running, if your company has less than $10 million turnover, then you need to pay $1,200 of levy each year. The employee is sponsored, and $3,000 of one-off levy payment during the time of nomination if you're applying for any RSMS or ENS. If your company has a turnover of more than $10 million, then you need to pay $1,800 levy each year the employee is sponsored, and a $5,000 one-off levy for during the time of nomination if you're nominating an employee for permanent visas. So the exemptions available for mostly people who have already applied for 457 before March 2018 is that applications who have applied for 457 on or before 18th of April 2017, which was later granted, so 457 which was later granted but applied before 18th of April. The age requirement is 50, so if you're applying for permanent visas after 457 and your age is 47, 48, which is more than 45, you can still apply for your permanent visas if you have applied for your 457 on or before 18th April and the 457 was granted eventually. The residency requirement of instead of 3 years, the residency requirement is 2 years. So according to the new rules, you need to be working on a 482 for 3 years to apply for permanent visas. But there is an exemption to this. If your 457 has been applied on 18th April or before that, then you need to work for the employer for 2 years and then you can apply for your permanent visa through employer sponsorship as well. So, if you have any questions or queries regarding to employer sponsorship, feel free to contact us on the information provided to you on the screen. We have office in Sydney, Darwin, and Ahmedabad in India and Kolkata in India as well. Thank you and have a good day.